Hello, everybody. Very pleased to be joined by a colleague of mine, a wonderful attorney. Her name is Lorianne Cercinia. And today, Lorianne and I are going to have a conversation all about employer-sponsored green cards. This is a topic that gets a lot of attention. There's a lot of interest. My vision for this video is to really dive deep into employer-sponsored green cards and give you a picture of what they're all about, what the requirements are, and we're just going to have a conversation about a lot of in-depth points that I think you're going to find interesting. So without further ado, we'll jump right in. Welcome, Lorianne. So happy to have you on today's video. Thank you so much for joining us.
Thanks, Michael. Yeah, I'm glad to be here with you and talk about PERM, which is one of my favorite immigration processes. I know not a lot of attorneys can say that, but I do really like PERM.
Yeah, and I can definitely attest to that. Lorianne and I have worked on many PERM cases together. And when Lorianne and I were first starting to get to know each other, I would ask her, like, what types of immigration cases do you like and what don't you like so much? And I can attest that she said without hesitation, I love PERM. PERM is my favorite. So she's definitely right about that. So with that, why don't you provide us with a high-level overview on the PERM process? What's it all about? We're talking about employer-sponsored green cards, and then we're just throwing in this word PERM. Give us a little bit of background and just an overview on the PERM process and all that kind of stuff.
Well, PERM stands for Program Electronic Review Management. Everybody just calls it PERM. It's also known as a labor certification, and I usually just dumb it down to U.S. labor market test is basically what the PERM is. PERM is the first stage of a three-stage green card process. So PERM is a U.S. labor market test, and it generally takes about 2 years to get through. Once you get your PERM certified, then you can file the I-140 petition and then the I-45 application, which is the actual green card application. The employment green card process generally takes 2 or 3 steps, depending on which employment category you apply under. We refer to them as EB categories or employment-based categories. The majority of applicants apply under EB2 or EB3, and EB2 and EB3 require you to run PERM recruitment. So PERM itself involves 3 main steps. 1 is obtaining a prevailing wage determination. 2 is running recruitment or conducting the labor market test. And 3 is actually filing the ETA Form 9089 or the PERM application. Based on current processing times, it is taking about 20 to 24 months to get through the entire PERM process from start to finish. And most of the wait time is waiting on the DOL to either issue the prevailing wage determination or adjudicate the PERM application itself. But once your PERM application has been certified, you can file stage 2 of the green card process, which is the I-140 immigrant petition. And then if and when your priority date becomes current, you can file the I-45 application, which is the actual green card application and the third and final stage of the green card process.
Got it. Thank you so much for that succinct overview of that. When you take all the process together and you take all the steps, there's so much to it. But thank you for kind of succinctly breaking it down like that. Basically, we have PERM is the first part of this process of getting an employer-sponsored green card. Like Lorianne mentioned, it's a test of the labor market. So an employer has to show that they tried to get a U.S. worker for their position that they have available. So the first thing is they go out and they submit a prevailing wage request with the Department of Labor. And the prevailing wage request specifies what type of job this employer has a need for. What are the duties of that job? What are the experience requirements? And they submit that to the Department of Labor, and then the Department of Labor will come back with an appropriate wage for that job based on the location of the job and the skills required and the amount of experience required and all of that. And again, once that prevailing wage comes back, the employer has to conduct recruitment. They actually have to go out and try to find a qualified U.S. worker for the position. And only after they go through that recruitment process and they're unable to find a qualified worker are they able to then file the PERM application, again, which is filed with the Department of Labor. Then, as Lorianne mentioned, there's a lot of waiting throughout all these different steps. There's a lot of waiting once you submit the prevailing wage request, then you go through the recruitment, and then you file the PERM application, and there's a lot of waiting associated with the PERM application just for the Department of Labor to process it and to come back with certification of that PERM application. And then once that PERM application is certified, then you go to the next step of the process, which is done with USCIS, where a Form I-140 is filed, the immigrant petition. And then lastly, you'll either do consular processing, which is applying for an immigrant visa abroad, or doing an adjustment of status. which is, as Lorianne mentioned, it's the green card application from within the United States. So it's a multi-step process. It's a process that for somebody that has not done it before, it can be extremely complicated. But for somebody that has done it many times, it's quite routine. It can be broken down into a system where each step gets completed at the appropriate time and things can function rather smoothly. So thank you so much for that, Lorianne. Let's go to my next question, which is, what are some of your biggest tips for somebody that's applying for this process? What are your biggest tips for somebody that wants to have a successful outcome doing this? What would you tell them?
I think the number one most important tip is to make sure that you hire an experienced immigration professional who understands the process and stays current on the latest perm regulations and latest trends. I myself have 17 years of experience working on perm application, and I'm still learning stuff all the time. There's always new regulations coming out. And this year alone, they did release a new form, and I had to do a lot of research into how to fill out the new form and how to avoid pitfalls in filling out that form.
We'll get all into that new form and what the differences are and so on and so forth. But thank you for bringing that up and alluding to that. Please continue.
Sure. Yeah. The other tip I would say is you need to properly draft the job duties. Drafting the perm job duties and listing out the actual requirements is really important to help you avoid delays at the prevailing wage stage, and also to ensure that your perm application is eventually certified. If you don't list your job duties clearly, the DOL could have a hard time assigning an occupational category for your position. They might assign the wrong occupational category. So it's important to draft the job duties in a way that you get the occupational category that's correct for your position. Additionally, when you're listing the education, experience, and skill requirements, you need to make sure that you consider what possible wage level it might fall in, depending on how much education and experience you require. So drafting a proper job description is probably the second most important tip. I think the last part is obviously making sure that you fill the ETA 9089 perm application properly. Sometimes there can be fatal typographical errors on an application that cannot be corrected after it's been submitted. So it's important to make sure that you fill out the form properly.
Those are all amazing tips. And what these tips really go to show you is that it's not just simply filling out a form. As you mentioned with the prevailing wage request and putting together the job description and the job duties, there's strategy behind that's done. We'll get to that later in this conversation as well, but it's not simply just taking some duties and putting them on a job description and then submitting it. You have to be strategic in how you word the level of experience that you want, the specific skill set that you're looking for, and so on, because it will have lasting implications, like you mentioned, in terms of what wage is going to come back and various other components as well. So great tips. Thank you so much for sharing. We'll continue. And I want to go into what are some common reasons why a perm case might get denied.
The most common reason I think a perm application might get denied or even experience delays is if there are errors, typographical errors, or just missing information on the actual perm application. So the perm application is an online form that is filled out. There's a bunch of check boxes, a lot of fields that you have to fill in. If you check the wrong box or forget to enter something into a field, it could be fatal and cannot be corrected unless you submit an entirely new application. So it's important to make sure that the attorney that's preparing your application knows what they're doing. And also it's important for the employer and the employee to review the application carefully to make sure that the information is accurate and correct. Some of the other common reasons that a perm might get denied is not following the proper recruitment steps, such as advertising the job position in the appropriate media, contacting potential applicants, and also documenting the recruitment efforts. So sometimes an audit might be issued for a perm application after it's been filed. If it is audited, you are required to provide evidence of your recruitment efforts. If you don't have the documentation or you didn't run the proper recruitment efforts, your application could get denied. Another reason is not advertising the prevailing wage for the position. And also there's wage transparency laws in several states now that do require you to advertise the salary. I know some employers may fail to advertise the salary requirements, and that could lead to a perm denial. Additionally, not providing sufficient or accurate information about the job requirements, duties, and qualifications, or making them too restrictive or unrealistic for the position could lead to a denial. Not timely responding to an audit letter or not providing the requested information to the DOL could lead to a denial. Lastly, I think another most common one is not providing information in the application to show that the foreign worker meets the actual minimum education, experience, or skill requirements for the position. So in the form itself, you have to enter information about where the foreign worker obtained their skills. If you fail to include that in the application, it could lead to a denial. Or if you fail to list a certification that's required or a license, those are like very simple things that are often missed in an application that could lead to a denial.
That was a very thorough answer. Much appreciated. Those reasons for denial highlight the importance, like you said, of making sure that you're working with somebody that has a great deal of experience in this field because it's very technical. You think of recruitment as an employer, you think, oh, I have to recruit for the position. I'll just post some ads and we'll satisfy the recruitment requirement. No. There is so much just in the recruitment component alone regarding how the ads have to be structured, what ads need to contain what specific information regarding the duties and what have you, and where the ads have to be posted, and specifically which ads require you to list the wage, which ads do not necessarily have to list the wage, and the requirements go on and on and on. So again, it's highly technical. To somebody that's never done this before, it's riddled with room for mistakes, but for somebody that's done it for several years, they know what to look out for, and it makes all the difference. Thank you so much, Lorianne, for helping to clarify some of those reasons for denials. Now, we alluded to this a little bit earlier. The PERM application, the ETA Form 9089, recently underwent some changes. So what I'd like to ask you is, how is this new form, this new PERM application different from the previous PERM application? And I would like to also know, why do you think these changes were made? And what do you think the end result is going to be of these changes? Specifically, some people are of the opinion that these changes are going to result in fewer audits. Some speculate that these changes are going to result in more audits. And so I'm interested in your kind of assessment of that and what your opinion is.
Okay, sounds good. Thanks. My response is mainly going to be kind of my opinion and interpretation of what I'm seeing. So I think the DOL has been trying to streamline and improve the ETA Form 9089 for years. They did roll out a new form this summer, which I believe is meant to reduce audits and the number of automatic denials. They did change like the wording in the form to help improve it, make it clearer. They also added some additional questions that often were audited in the past. So there are a few additional questions in there, but they did create a section that discusses the employer requirements. It's too early to know if there's going to be less audits. I know just between the immigration attorneys, at least that work in this field, there have been a lot of questions and concerns that have come up, but honestly, it's too early to know. I mean, we'll probably start receiving certifications in the next couple of months, and hopefully there won't be any automatic denials, and hopefully there'll be a lot less audits, but it is too early to kind of say.
Just to touch upon this, so in the context of a PERM application, you file the form ETA 9089, and there you list various aspects of the PERM case, and the Department of Labor can either certify that PERM application or they could audit the application, essentially requesting additional evidence on the filing. They might ask for evidence of all the recruitment that was done, to see evidence of the ads that were posted, of any applicants that came back as a result of the recruitment. They may target that, or they may also target other elements of the application as well. For example, they may ask about somebody's underlying status and whether that jeopardizes whether there's good faith recruitment in the application. Correct, Lorianne?
That's correct, right. They do ask about familial relationships in the new form, and they ask whether there's ownership interest. That's two questions that were in the previous form, and I think they're trying to add those to avoid receiving audits on future PERM applications. But if you filed a PERM application, the old form, and there is some ownership, possibly some familial relationship, there's a good chance that your PERM application will get audited.
Yeah, so that's another thing that I was kind of alluding to. So with respect to the changes in the PERM application, there's specific questions, like Lorianne mentioned, whether there's a familial relationship between somebody within the company and the beneficiary, the person that's ultimately going through this process to receive their green card. And there's also various questions that go hand in hand with the reasons why cases will routinely get audited. So the question is, are these questions being asked in the application to reduce audits by asking for the information up front? Or are these questions being asked to elicit further audits? It's interesting, and time will tell. Again, as Lorianne mentioned, it's quite early, and the new perm applications only recently rolled out. Very interested to see how it all plays out, and hopefully it will ultimately result in reduced audits, because assuming everything was done properly, an audit should not impact a case. Cases should still get approved regardless of whether an audit takes place or not. But the downside of an audit is that it can really delay a case. So again, hopefully this new application will reduce the number of audits that the Department of Labor issues. Again, time will tell, and we hope for that. But I wanted to kind of move on, and I wanted to ask you a more personal question, but I wanted to ask you to share one of your favorite success stories of one of your clients that had their case approved. Maybe you can share some facts about the case, of course, keeping everything confidential, but I would love to hear a success story that particularly stood out to you.
I don't know if I have one favorite success story. I'm always relieved when a perm application is certified without an audit. So I'm always just thankful that it gets certified. I filed hundreds of applications over the past 17 years as a paralegal and attorney. I think the cases that stand out to me the most are the cases where someone might be running up against a visa max date, and we have like a set amount of time to get their perm certified and file their I-140 petition and possibly file an extension, possibly because their H-1B visa is maxing out. Those are the cases that I feel like I just follow along. And because it takes so long to get through the perm process and to get to that I-140 petition, I feel very invested in making sure that we hit all our timing deadlines on time. So there's been so many cases that I've worked on. I'm relieved when it is certified.
It's nothing to take lightly. We'll move on. And I want to go into some more specific questions that routinely get asked. And I think that they're questions that a lot of people are curious about. First and foremost, can a brand new company sponsor a foreign worker for a green card?
Generally speaking, a brand new company can sponsor a foreign worker for a green card, but they're likely to face more challenges, definitely more scrutiny than a well-established company. One of the main requirements for sponsoring a foreign worker for a green card is to demonstrate that there is a bona fide job offer and that the employer has the ability to pay the prevailing wage for the position. For a brand new company, it may be difficult to prove that they have the ability to pay, especially if they have no revenue, assets, or payroll records. Also, they may have a difficult time showing that they have a legitimate business need for hiring a foreign worker and that they have made good faith efforts to recruit qualified U.S. workers when their company is still quite small. I don't recommend brand new companies sponsoring a foreign worker until they've established ability to pay and show that they are able to make good faith efforts to hire a U.S. worker. If you're a new company, I would definitely reach out to an immigration attorney to talk about your specific situation and determine if there's a strategy that we could do to proceed with a perm process for one of your workers.
Just to jump in and just clarify. So assuming that it's a brand new company, but it is able to demonstrate ability to pay. Let's say they've infused cash into the business's operating account that equates to whatever the prevailing wage would be, and they have that amount liquid in cash, then there is theoretically a path forward to file a perm application, assuming the other requirements are met as well, correct? If it's a brand new company.
Right. I'm not saying it's impossible for a brand new company to sponsor a foreign worker for a green card process. It's just they'll face more scrutiny. So they'll most likely provide financial documentation to show their ability to pay. They'll probably have to provide payroll records to show their employee headcount and who's on payroll. It's not impossible, but definitely they will face some scrutiny.
Got it. Okay. So next is, can you do the perm process for yourself? For a company that you're an owner of? Can you basically sponsor yourself for a green card under the perm process?
So I wouldn't recommend an owner sponsor their own perm process. As the owner of a company, you have ownership and control over your company, and it'll be difficult to prove that there's a bona fide job offer available to other U.S. workers. So part of the perm process is running that U.S. labor market test. You have to run it in good faith. If you're the beneficiary of that perm process and you're the owner of the company, there's kind of a conflict of interest, and the DOL will likely question the company's good faith efforts in actually recruiting for your position. It's going to be difficult for you to demonstrate that the company has a genuine need for your services as an employee. So I wouldn't recommend it. Additionally, I think conducting perm for yourself as the owner of a company may violate the rules and regulations of the perm program and the recruitment regulations, which could ultimately lead to the denial of your application. I would definitely explore other options if you are the owner of a company, other green card options in lieu of the perm process. I don't think it's the best option for owners.
Got it. And we'll get to some alternatives to perm in a bit. Thanks for kind of setting the stage for that. And thank you for that answer. So let's move on and go into timelines. People are often curious about how long this process will take. So can you share some information about exactly that? How long does the perm process take when you're going through the multiple steps from the perm to the I-140, etc.?
The entire perm green card process, from perm to the I-140 to the I-45 or consular processing, is going to be anywhere from 3 to 4 years, right? At least. The perm process itself is currently taking 2 years to complete, and that's just the first stage. So the reason the first stage takes so long is because the prevailing wage is taking about 8 months to receive a determination. And then we run recruitment for at least 2 months, but it's 2 to 4 months for recruitment, depending on how quickly HR can review the resumes received and complete all the recruitment documentation. And then once we file the perm application, it is taking about 11 months for the DOL to process the perm application. Historically, processing times have just continued to get longer and longer. I think in the past, there was once upon a time, you could get a perm certified in 6 months or less, but now it's nearly taking a year to get a perm application certified. Once you do get your perm certified, you can premium process the I-140 stage. So it's possible to get through the I-140 stage, I would say, in about a month. And then once you have that I-140, it really depends on whether your priority date is current. And if you're going to be filing an I-45 adjustment of status, it could take anywhere from 8 to 12 months, I would say, on average, but it does vary from candidate to candidate on how long it takes for the I-45 application to process. So it is very long. It's going to take several years. I'd say minimum 3 to 4 years to get through the entire green card process. If you're from one of the backlogged countries, India and China, India has the longest visa backlogs. I mean, you're looking to wait at least 7 to 8 years for your priority date to become current. The good thing is once you have your I-140 approval, if you're already in the US and H-1B status, you can continue extending your H-1B beyond your 6-year visa max as long as you have that I-140 approval. So that's one reason to start the perm process and get the I-140 petition. But if you do have the I-140 and you're doing consular processing from outside the US, you will have to wait 7 to 8 years before your priority date becomes current. And when I'm talking about priority dates, there's a visa bulletin that the Department of State publishes every month, and it lets you know which priority dates they are accepting green card applications for.
Thank you so much. So next is, in your eyes, who is the ideal candidate to go through the perm process? What are their characteristics, whether it's the company or the beneficiary, however you want to interpret that question?
So an ideal candidate, I think, often comes down to the company. A lot of the tech companies have a requirement that anyone that they sponsor for perm needs to at least have a bachelor's degree before they'll consider sponsoring them for a perm process. They may even require you to have 1 to 2 years of experience. Some companies might not even consider filing a perm application unless they've had at least 3+ years of experience, just because if a position can be easily filled by another US applicant, then they probably won't sponsor your perm process. I think times have changed in the last 10 years or so. I think there's definitely a shortage in hiring for certain positions, especially in the technical field. So I think most companies now are willing to sponsor candidates who don't have any experience and may just have a bachelor's degree. But if you don't have a bachelor's degree, if you have a position that is a technical, professional position and you have years of experience, you don't necessarily have to have a degree to do the perm process. So I think the best way to figure out is to talk about it with an immigration attorney to determine whether or not they think that your position is skilled enough to survive the U.S. labor market test, because the goal of perm is to file your case. What do you think is an ideal candidate?
I would kind of interpret it an employer that's committed to the process and will work as a partner with their legal representative throughout the process so that when we do hit the various benchmarks that are needed, for example, when it comes time to submit the prevailing wage request and review the finalized version or the draft version before it gets posted, they're right there to say, yes, this looks great, or provide their input if there's something that they would like to be tweaked. And when it comes time to run the recruitment, they're communicative with you to undergo the various steps like setting up their SWA account or what have you. And then again, when it comes time to review the perm application, there's so much of a collaboration between the legal team and the employer. I think having an employer that's committed to the process really makes a tangible difference in how the process unfolds. And then also, of course, just baseline requirements, I think, are extremely important. Making sure that the employer does have the ability to pay, making sure that the employer understands that once the prevailing wage comes back, they actually have to pay that amount or more. It's not a suggestion. It's not like the prevailing wage came back at $50,000, but I'm going to pay the employee $15 an hour. It doesn't work that way. So an employer that's understanding of the requirements and that is engaged in the process with you, I think that makes all the difference in the process. I wanted to go now back to the prevailing wage request. And we talked about earlier how there is such a strategic component to it. So how do you balance setting qualifications for the position, not going overboard with tailoring the job to the qualifications of the beneficiary, but still tailoring the prevailing wage request so that it's not so basic as to elicit a flood of incoming applicants? How do you navigate that process?
Sure, I get asked this question a lot about the job text. I think there's a misconception about how the job text is drafted. To be clear, the perm job requirements are based on the actual requirements for the position, not on the employee's actual qualifications. Although we will want to consider the employee's qualifications when we're drafting the minimum requirements, it should be based on the company's actual requirements. Employers should be careful to not tailor the job requirements to the employee's qualifications because it could lead to an audit and possible denial of the perm application. When considering what is normal and what the actual requirements are, companies should look to their previous job postings to see what they actually required for the position or other similar positions. If they're not sure, they should look at other job postings that are similar, that are required by other companies in the industry. There's also a difference between preferred and minimum requirements. A job tech should only include the minimum requirements and not include preferred. For example, an employer might prefer someone who is bilingual in Spanish and English, but if it isn't actually required for the position, and if they've hired other employees in the past for the position that are not bilingual, I'd probably leave out that requirement. So it's a careful balance of considering what is actually required for the position and also what experience the employee has, because a big part of the perm application is that the perm employee needs to meet the requirements for his own position.
Understood. So basically, the job is not at all supposed to be tailored to the employee's qualifications. Of course, it's imperative that the employee at least meets the minimum requirements for the position, but the employee's background and their credentials cannot come into the picture in terms of what the employer is requiring for the position. What the employer is requiring ideally should mirror what they typically require for such a position based on evidence of like past job postings, etc. Right?
Correct.
Okay, cool. So let's go to alternatives. What would you say are some alternatives to the perm process?
So there are different categories of employment-based green cards. If perm is not a good option for you, there's also other EB categories such as EB1, which is for extraordinary ability, outstanding professors and researchers, and also for multinational executives and managers. What's nice about the EB1 is that you get to skip the perm process and go straight to the I-140 process. However, EB1 is definitely holds a much higher standard of proof. So there's a lot more documentation involved, which also means that there's a greater chance that the case might not be approved under EB1 category. So if you think you might fall under EB1 category, it's good to talk about it with an immigration attorney so that they can consider your qualifications to see if you might qualify under that category. Please note that EB1 takes several months to get through just because there's a lot of document collection, but still it's faster than having to do the perm process. Additionally, there's like EB5 category, which is for investors. If you're able to, I think it's like 800,000 minimum investment.
Minimum investment of 800,000 or 1,050,000, depending on the location of the business.
Right. So EB5 is another alternative if you're able to qualify under EB5. It's Also, very high standard of proof, and the process is long to get through, and the chances of receiving an RFE are high. And additionally, the risk of it not getting approved or getting denied is probably much higher than going through the perm process. Some other categories you might consider is a national interest waiver for applicants who are in occupations that there may be a need for or a shortage of in the US, like nurses and doctors. So those are some alternatives I would consider in lieu of the perm process. But realistically, I would say the majority of employment-based green card applications are under EB2 and EB3, which require perm.
Got it. Great answer. You put some gems in there. EB1 for people with extraordinary ability, EB2 national interest waiver for people that are doing something in the United States that can be classified to be in the national interest, like a cancer researcher of some kind. And then you also brought up EB5, which is an investment-based green card option for people that are going to invest, like Lorianne mentioned, at least $800,000 in a U.S. business and create jobs for U.S. workers. So some great alternatives there. And lastly, I just wanted to finish off and ask you, is there anything else that you'd like to mention? Is there anything else that you'd like to close with? Any other comments or any other aspects of perm that we may have not covered? The floor is yours.
I think with perm, I think it's important to start the process early, well before you are running out of time in the U.S. So make sure that you reach out to a U.S. immigration attorney to talk about your perm green card process and timelines and kind of outline the expectations so you know what to expect.
Okay, perfect. Well, Lorianne, thank you so much. I know we covered a lot of ground on this video. Thank you so much for taking the time and joining today. Hopefully we can get you back on another video sometime in the future. Again, thank you so much. And thank you to our viewers. Hopefully you got a lot of value out of this video. Hopefully you learned a little bit more about the intricacies of the perm process. And if you have any questions, don't hesitate to just drop them in the comments below. And maybe if we get a number of questions, we can film a part 2 addressing some of the things that may have not been covered in today's video. Thank you all. And as always, see you on the next video.